ask further questions.
Thank you, Chair, and Honorable Hamadi. I heard you mention about Ghana, how they have been able to hold successful elections. And I would wish that should you be given this position, you also do a benchmarking. I think in the same Ghana, there are other electoral commissions where the chairperson of the commission has been given executive powers. They are also accounting officer.
Okay.
Reason being that, and you'll note from our country, there have always been an issue of the roles between the chair and the accounting officer. So
right.
there are successful commissions that have actually given those roles.
Oh, I didn't know
chair.
that. Thank you.
So just for your information.
Thank you.
Now, a follow-up question on what Professor Olo has put it is on how would you handle conflicts? You will appreciate that Iebc, there are many actors or stakeholders who would want to control the operations of Iebc. You go to Treasury, they don't give them adequate funding, they delay the funding, it affects their processes. There are other stakeholders who tell them they have no powers to make regulations, despite the fact that they are an independent commission. So there are also cases, and this has been reported in the past, where even staff members of the commission were being alleged that they took partisan roles in the election process. So if you get this position as the chair, how will you work around using your leadership skills and your experience to ensure that all these stakeholders are brought together and that the commission achieves its mandate? Thank you.
Thank you, Chair. I'll just give an example of what happened in the run-up to the 2022 elections. There is a framework that was put together which was called multi-agency team or something like that, that brought together all the agencies. There was judiciary, there was police, there was treasury, there was Ministry of Interior and Iebc. Basically for purposes of just seeing how the Iebc could be supported to be able to conduct a successful election in 2022. And they had several meetings where the Iebc, outside of the normal framework, was able to indicate the kind of support that they needed, the kind of timelines within which they had to do what they needed to do. And there were certain commitments that were made by the various agencies. But I know that at some point, again, Iebc stepped out of that framework for some reason. I think it was a good initiative that can still be tried. The reasons as to why Iebc stepped out of that framework are not so clear to me at this point in time. But I've always believed that when things are done in a consultative way, through a cooperative framework, they tend to just work better in terms of people understanding that this support needs to be given so as to avoid delays, so as to hinder the processes of the commission. On the issue of staff playing partisan roles in the electoral process, that's very unfortunate. I think you have to be able to disrupt certain formations within the commission. There's a way in which staff can be taken through. They can be taken through processes that can help their mindsets, but again, it shouldn't be too. Certain administrative interventions can be made to make sure that it's difficult for staff to do to carry out their activities, their duties in a partisan manner. For example, if someone was expecting to go and oversee the elections in Nakuru and last minute they're taken to Kajiado, then they may not be able to do what they had planned to do. So there are certain administrative interventions that can be put in place to just make sure that we minimize on the mischief, if any has been planned. But I'm sure with a team we'll be able to discuss and just see what else is possible to be done, so that people are just following the regulations, the rules. I know what we did in the judiciary for most of the things, because when I went there, I found that there were no standard operating procedures, there were no manuals. So we had to prepare a lot of manuals that everybody had to stick to. Everyone had to stick to, so that then everything is done in the correct manner. Again, technology can help, because when the system is secure, then there's some of the mischief that can be prevented from taking place, even if the human nature wanted to, interfere with the process.
Lastly, and related to the multi-agency team, which I think I attended one of the meetings at Safari Park.
Yes.
If in that process of having a multi-agency team, some stakeholders, you observe that some stakeholders could be pushing for an agenda that is contrary to the mandate of Iebc, what would you do?
The Iebc would have no choice but to stick to what is right. And maybe if the agenda is then contrary to the principles that Iebc is expected to follow, and maybe that is the reason that what happened last time did happen. It might get to a level where you have to step out if it is not serving the interests of the nation, if it is not serving the interests and the objectives of the commission. Yeah.
Thank you very much. The media might just call you the disruptor of IEBC if you got this position. And so thank you for those answers. I want to ask Professor to ask you some questions.
Okay.
Madam Anna Madi, I see from your CV that you have also done a lot in FIDA and gender-related matters.
Yes.
And therefore I believe that globally you follow advancement of women issues and gender issues. So my first question to you on that is, which African country recently elected its first female president?
I see her. Namibia.
Okay, proceed.
The Senate represents counties, and we have 47 counties, but we also, in terms of the number of senators, we have 67. How do you explain the extra 20 as per the Constitution and Elections, IBC and Elections Act?
The extra 20. Those would be the special seats for women, for persons with disabilities, for the marginalized, those special interest groups. And they come in through party lists which are submitted to the IEBC, and those party lists cannot be changed. They're final. And so the parties are assigned the nominated seats based on a pro rata basis. So that is how the 20 come in. Thank you, Chair.
Thank you, Chair.
Thank you. Madam Amadi, you are aware that by law we are required to ask for public participation
Yes.
on the candidates that we shortlist, but also to do some due diligence around them.
True.
One of this matter that has been brought to your attention is a matter through a memorandum dated 19th of March 2025 by an individual who says that he's a citizen of Kenya, and he claims in his memoranda the following. Alleges that during your tenure as the registrar to the judiciary and also as secretary to the Judicial Service Commission, you failed to comply with express court orders and or the directions in matters in which the commission was directly involved. So the rule of law. Number B, the petitioner claims that in the case 34, petition 34 of 2014, in which JSC was directed to publicize procedures for all its, let me just use my glasses, for all its disciplinary and investigative processes within 90 days of the judgment, he claims that you did not comply with that judgment. C, the petitioner cites the case of the Republic versus Salaries and Remuneration Commission and two others, civil application number 58 of 2020, in which the court ordered payment of backdated salaries to the judges to be refunded, which you disobeyed. Number D, it says that maybe I should ask the Vice Chair to pick up number D and E, kindly, just to clarify and put the questions to you.
Thank you, Chair. It's just a continuation, Honorable Ahmadi.
Yes.
That the memorandum also states that it was alleged that you should not take a lead role in Iebc, now given your past work record according to his memoranda.
Yes.
And also that he requests the panel to indulge you on how, during your tenure, you assisted the judiciary in handling rampant corruption complaints within the judiciary. Thank you, Chair.
Okay. Thank you very much, Chair. I saw the petition last night, so I didn't have an opportunity to engage with it thoroughly and to give a comprehensive response. But nonetheless, I will say this, that the decision that whoever the complainant is talking about related to judges' salaries. Salaries of judges are not paid by the judiciary. They are a direct charge to the consolidated fund. So that when a decision like that is made, then my role is to communicate to the National Treasury for effect, which I did. And if I had had an opportunity, then I would have found a way of getting the material to respond. But I did comply, and so it is the executive that pays the judges directly. The chief registrar only pays the magistrates and the staff. So the rule of law was followed. Then the one on...
So did you advise the
National Treasury?
Yes.
Yes, we did advise the National Treasury, and I think the SRC as well, because it had a huge budgetary implication. Then the one that, what is it? The one on corruption cases, I think I had responded partly when panelist Bor, sorry, I hope that I got the name right, asked me about my case. We had a very comprehensive framework for dealing with cases of this nature. We even had cases where, I'll give an example of a case where a magistrate was actually arrested and charged for corruption. And the case went on and she was acquitted, but the JSC still let her go because JC was of the view that yes, the court has acquitted you, but from the evidence that we have, we can see that there is clear misconduct. So it is not correct that we did not deal with corruption cases. There was a day that we lost 5 magistrates in one day for these kinds of malpractices. So it is not correct that we did not handle those cases. We did. The challenge, as I said earlier, is that a lot of allegations are made with very little evidence, if any. So when there is no evidence, then it's a bit difficult to deal with it conclusively. You can deal with it by way of engaging the individual, but where there is evidence, the Commission has been very strict in addressing this issue. Thank you, Chair.
Thank you very much. We apologize that you got this last night. The memoranda came to us on the 19th, which is a few days ago. If you can be able to help the Secretariat with some of that material you have mentioned, just to be able to confirm your response.
Yes, I will try, because I'm not in the judiciary anymore. So it means asking someone to help me retrieve that. I will make the attempt nonetheless. And maybe you can give me the timeline within which that should be done, so that if I'm able to get the material, then I'll be able to respond more comprehensively.
Do that in the course of this week.
Okay.
Yeah, today is Monday, so if you do that by Friday, it will be okay.
Thank you, Chair.
Yes. Allow me to thank you for coming.
Thank you for having me.
And to just say that we have enjoyed interacting with you. We have learned a lot about your work in the past, the judiciary, your work with FIDA, your community engagement, and we are grateful to the responses you have given to us. I'd like to ask you if you have any question for us, so that we can be able to respond, if at all.
Mine is just to wish you well. It's a challenging process, very daunting, but you have what it takes. So I just want to wish you well and to thank you so much for having me. May God bless you.
Thank you very much. You have a bottle of water before you. Feel free to take it with you. Ensure that you have your certificates and your documents so that you don't leave them with us. And
because of the high pressure, the nature of the work, just taking an example of during the elections period, when there's so many petitions being filed post-election, you have to have resilience. You have to be able to put in many hours, just hard work. You have to be able to guide. You have to be able to rally people around an issue so that you move together. You have to have very good coordination skills so that you know what every court is doing at any given time. You have to know what they need at any given time. You have to make sure that they're provided. You have to have very good financial management skills. You have to be able to ensure that procurements are done on time. They're not able to ensure that procurements are done on time. There are no delays. Sometimes we had difficulties when budgets were released late, but then there would always have to be a way of doing things in such a manner that services are not interfered with, are not stopped. Again, we had to have, it was important for us to know what the public feels about our services. So it was about reaching out through the court users committees, through our customer surveys, just to be able to know what is it that people want, what are we doing wrong, how can we do it better. So those are some of the skills that we had to put to use.
Fair enough. Thank you very much. I would like to ask Madam Caro Kituku to ask some questions, kindly.
Thank you so much, Chairman. Honorable Mandi, if you are appointed the chairperson of the IBC, your knowledge of the law and the legal systems that governs the IBC will be critical in offering the strategic leadership, direction and guidance to the Commission. As you may know, Parliament is required to enact various laws that give operationalization to the various segments of the IBC mandate. One of those laws could be the referendum law, the financing of campaigns law, the boundaries delimitation laws, just to mention a few. However, those laws have not been enacted to date. What do you perceive that to be, and how does that interfere or present challenges to the operations of the IBC? The failure to enact those laws.
Indeed, the failure to enact laws to operationalize the IBC should be a concern to all of us. For example, on the referendum law that you have mentioned, currently we do not have a framework for conducting a referendum, so that if we needed to have one today, then there will be a challenge. How do you do it? How do you even frame the referendum question? I'm aware also that Article 100 that talks about the participation of women, persons with disability, the marginalized and all that, has not been operationalized. So it leaves us in a place where it is difficult to meet the objectives of the Constitution and what was envisioned by Kenyans when they demanded for those things in the making of the Constitution. I'm also aware that the Iebc has attempted to seek advisory opinions on some of these matters. For example, where we have delay in the issue of boundaries delimitation. So what happens? The Supreme Court has also delayed in giving that, meaning that then there is no clarity on how we move in terms of conducting the boundaries delimitation. The Campaign Financing Bill Act was stopped by the court for certain reasons. It was a good law, according to me, that would have helped us to decommercialize campaigns and elections. It would have helped us to be more accountable, more transparent in the sources of funding when it comes to elections. But there is a conservatory order that is still there since 2017, and I think that issue needs to be resolved. And some of these issues can be resolved just by reaching out and having continuous engagements with the different stakeholders. I know that Iebc is not a member of the National Council on the Administration of Justice, which is the council that brings together all justice actors in civil society, the state actors as well. But Iebc was actually co-opted as a member of the National Council. So that would be a good forum, because I know that at some point Parliament also joined in. As secretary, they were not very consistent in attending, but that would be a very good forum to discuss these challenges, because it's in the interest of all of us that the Constitution is implemented as envisioned, and for as long as these areas remain hanging, then it means that there is something that we're losing, there's something that we're missing out on as a nation. Thank you.
Maybe a follow-up question on that. If you're successful and become the chairperson of the IBC, how do you propose to circumvent some of those challenges that have been brought about by the failure of Parliament to enact those laws, the lacunas in laws? Because in the meantime, IBC must perform its mandate.
What I see as an immediate low-hanging fruit is just continuous engagement, and also getting the general public to understand those issues. I know that IBC engages a lot in voter education, and my view has always been it shouldn't just be about how to vote, how to use the ballot, but why should I? Am I picking people who are going to make sure that these things get to happen? So we have to keep engaging at all levels, from the parliamentary level, Senate, and then the general public, other actors, so that we just develop a shared vision for this nation. Things that I think going forward, my view is that in Kenya we legislate a lot. We legislate on almost everything. There's certain things that there should be room for just administrative action, so that we are not waiting for law to be able to do everything. I think there is that issue of trust, and so because of that we tend to legislate even the smallest thing that can be done just administratively through maybe a policy framework, and then that would be my view. Thank you.
Having worked as a judicial officer, and obviously having had the experience of working as a chief registrar of the judiciary, how do you see, or what do you think is the role of the court in adjudicating electoral disputes, and particularly these disputes that regard to the lacunas in law? Does the court have any role or any function to do?
Okay, where there is, I'll begin by saying that yes, the court has a big role in adjudicating electoral disputes, and the legal framework allows for, we have the Political Parties Disputes Tribunal, which is a subordinate court under the judiciary, and then during the electoral, the election petition periods, we have courts gazetted to deal with disputes. So indeed, the judicial officer has a role to adjudicate on electoral disputes. Does the court have a function where there is lacuna in the law? Yes, it does, and mostly at the level of, because legal interpretation, constitutional interpretation, is a function of the High Court. So if a question comes, a question arises, the court would have an obligation to make a pronouncement. There is law that is called judgment law. I think the law can make a pronouncement that can guide. I know that the Supreme Court has dealt with a few advice. Given direction, some of which has been ignored. So I think as a nation, we also just need to develop the culture of constitutionalism and respect for the rule of law. Because when the court, with its authority, has made a pronouncement on an issue, then it's only right that we comply and we follow what has come from there, unless there is subsequent legislation that changes the position.
Tell the court to pronounce itself on this issue. Can the Iebc go to court to can Iebc go to court to compel Parliament to enact these laws and provide the required legislative framework? Is that something that would be that within the mandate of the court to do? Politically ideal for Iebc to do so?
Iebc compelling Parliament to legislate. I think Iebc can go to court and ask for anything. My only doubt is whether it would be the right way, the right path, because I believe more in engaging with the lawmakers taking into account the view that if the lawmakers are hesitant to legislate on a particular thing, because we know that the courts have also pronounced themselves on certain issues that Parliament has still not done. So we also don't want, even as you consider that as an option, you don't want to go through a process of that nature in futility. So I would still prefer the engagement negotiation process as opposed to an order which might be in vain. But yes, indeed, the court can pronounce itself and say, indeed, this law has to be passed because the Constitution says so. Yes. Thank you, Chair.
Given that during your time at the judiciary, there were constant complaints about inadequate funding.
Yes, I engaged a lot with the members, especially of the Justice and Legal Affairs Committee, and the members of the Budget and Appropriation Committee. And when I joined the judiciary, the budget was about 16 billion. When I left, we were at about 23. It was still way below our resource requirement, but progressively it was increasing annually. So we have to just keep at it, because the option is not to push for it and remain with nothing. So we kept engaging both informally and formally. During the budget discussion processes, we would prepare our resource requirements very well and explain the justifications for all those requirements. And we'd constantly compare the budgetary allocation for Parliament, which only operates in Nairobi, with the judiciary that has about 140 court stations across the nation. When I joined the judiciary in 2014, our budgets were at par, 16 billion, more or less. And within 5 years, Parliament had double the budget of the judiciary. Yet they operate only in Nairobi. They have very few staff compared to the judiciary. So they have that advantage that it's them to decide the appropriation of resources. The judiciary is, and it's not unique to Kenya, it is something that you see across the jurisdictions, that the judiciary tends to be the poorer cousin of the three arms of government. So it helps, it does help, because there are times when you're able to push and get something more, and you keep using it as long as you're using it with prudence. And as I said earlier, we had very little money, but money to have a very vibrant and robust ICT system, just with the little that we had. So we were able to be prudent in the use of resources, apply little to do much. So if you don't have enough resources, then it's about how do you apply it to maximize on what you have. Thank you, Chair.
Thank you very much. Appreciated. I would like to ask Madam Dr. Koki to ask you some questions.
Thank you very much, Chair. Good morning again, Honorable Amadi, and welcome to this interview session. It's not really an interview session. We're having a conversation, a dialogue. You spoke a little bit about over legislation. When you spoke, you said that some things can be addressed by administrative action and so on. We notice, however, that since the promulgation of the 2010 Constitution and the elections that have been held under the Constitution, we have seen every one of them, the validity of the election of the president has been questioned and therefore has been challenged in the Supreme Court. And after every decision of the Supreme Court, we have seen recommendations of reforms that are required, legal reforms that are required to be done in relation to the process of elections by the Iebc. And we have actually also seen from the strategic plan of the Iebc 2020-2024, they identified over legislation as a challenge for them. Yet we have seen this happening each time. So I wanted to ask you two small related questions. The first one was, in what areas would you say there has been specifically over legislation?
Okay, so thank you for that question, Chair. In what areas do we have over legislation? I'll give a small example.